Candace Owens responds to our exclusive story, and rapper Young Miami, the ex-girlfriend of Sean Diddy Combs, tells the judge he is a good man. Hello and welcome back to Fame Under Fire from BBC Sounds with me, Anoushka Mutanda-Dougherty. Coming up,
we're just going to all hound Candace to try to distract her from looking into Charlie Kirk's murder and assassination.
Candace Owens follows up on the news that Brigitte Macron, the French president's wife, will present scientific evidence in court to prove she is a woman. Plus,
nobody in the history of using prostitutes without a criminal record is being treated worse than he is. That's their strongest argument. And I think it might actually work.
Our resident trial attorney Shaun Kent's here to tell us what to expect at the sentencing of Sean Diddy Combs. As always, if you've got questions, send them to me on social media or WhatsApp at +44 330 678 114. Don't forget to subscribe to the BBC Sounds YouTube channel so you never miss an episode. Okay, so last week we brought you the exclusive that Brigitte Macron, the First Lady of France, is resolved to bring scientific evidence to present in open court in Delaware that will counterclaim she was born male. Now remember, the Macrons are suing podcaster and influencer Candace Owens for continuing defamatory attacks against them to boost her media platforms and make money. Go back and listen to that interview we did with the Macrons' lawyer and corporate investigator if you haven't heard it. Now we have a response from Candace Owens. Around 45 minutes into an episode of her podcast on the Candace Owens website, she says this.
Talk about a federal operation out of nowhere. Brigitte Macron just lies. I don't even know how they got this in the press. This is so dumb. Brigitte Macron comes out and says they have offered scientific evidence to the U.S. court to prove that Brigitte is a woman. That's what her lawyer says. Well, the lawyer's a liar because we haven't even started this case yet. So how could you have offered scientific proof to a court to prove you're a woman?
So the headline on the screen reads, Macrons to offer scientific evidence to court to prove Brigitte is a woman, lawyer says. The Fame Under Fire team know this because the Fame Under Fire team wrote it. It is very clear from the interview, articles and videos we did that the Macrons' lawyer, Tom Clare, says they will present scientific evidence. Will, as in the future tense.
The expert testimony that will come out, that will be scientific in nature, that will also demonstrate the falsity of the statements. And obviously, it's incredibly intrusive for this family to have to go into open court and present this evidence. But that should just demonstrate how serious they are about it, how confident they are in their ability to prove it as false in a public forum, and how they want to put this falsehood to rest once and for all.
So no one has said that they have already submitted evidence. In the same podcast, she also introduces the idea that our interview with the Macrons' lawyer had something to do with her investigation into the murder of conservative activist Charlie Kirk.
So I don't know what this is. Just like we're just going to all hound Candace to try to distract her from looking into Charlie Kirk's murder and assassination. But it's focusing me more because this is not normal. Like the amount of lying that's happening right now is because you don't think I'm strong enough to handle it and you're trying to break me. You're not going to break me, okay? I watched him catch a bullet in the throat and we're being lied to by everybody about who was involved, why it happened, and why you are attacking the people the person who is trying to investigate it.
Now, I just want to fact check that because this interview was booked before Charlie Kirk was assassinated. I can tell you this because I booked it. We have previously also covered the case on the pod as well on the 31st of July. Now, we contacted Candace's team directly and asked them if she wanted to say any more about the story. Here is what they sent over. Now, this has been voiced up by a BBC producer.
Brigitte's claim that she will offer scientific evidence regarding her gender in court is an obvious and pathetic public relations ploy. Brigitte has never once offered such scientific evidence, and to the contrary, when we offered Brigitte and her lawyers multiple opportunities to supply any form of proof that she was born female, she refused outright. In any event, it is not defamatory to say someone transitioned or is gay. We have filed our motion to dismiss and look forward to defending this frivolous case through the American judicial process.
Joining me now to cast an expert eye over all of this is our resident trial attorney, Shaun Kent. Hi, Shaun.
Hey, Anoushka, how are you?
I'm good. We got into some things last week. I really want to hear your opinion on all of it, but particularly the aftermath of that interview, which kind of went round the world, and what Candace has had to say. You can hear there that she's talking about the scientific evidence that they said that the First Lady is resolved to bring to open court in Delaware, saying that this is a PR ploy. Isn't it the plaintiff's prerogative what evidence they want to present?
100%. The plaintiff is the one who is bringing their lawsuits. So not only is their prerogative, it is also their burden. So they have a duty. They sued Candace. So they got a duty to bring their case and prove their case.
Now, when they spoke to us, Tom Clare, the lawyer, and Dan Nardello, the corporate investigator, when they spoke to us, they spoke about scientific evidence. They also spoke about an expert that is going to give evidence of a scientific nature, both generically, but also specific to Brigitte. Now, when you put an expert on the stand, is that also your prerogative when you bring them in, how you introduce them? Can you just put them in, or does the judge have to say, yes, this expert is qualified enough to speak to this?
We always used to make the joke that realistically, an expert is just somebody who can assist the trier of fact, and that's the jury, to understanding more. So technically, a fifth grader is an expert on the fourth grade. You know what I mean? So that can be an expert, somebody who just knows more than the jury. And so what the judge has to make the decision about is this person, do they have the qualifications necessary to assist the jury? And is the thing that they're talking about something that you would need an expert for? So in other words, you can't have an expert in witchcraft if witchcraft doesn't exist. You have to have something that has scientific value. So once they get to that threshold, and we have a standard, we have cases called Daubert and Fry. Those are the cases in which experts have to show that the things that they are testifying about have scientific validity. And if they can prove that, then those individuals can testify.
Now, to the point that they didn't offer evidence to Candace, I asked that question because I've had that question for a while. Why not just give her pictures, I asked, of Brigitte pregnant? And that is also something Candace and her team are echoing here. We asked that question directly to Tom Clare, the Macrons lawyers, and this is what he said.
When you're dealing with someone who has not demonstrated a level of responsibility in the way that she handles facts and evidence, handing more evidence to her versus other responsible journalists doesn't make any sense. And so we are prepared to supply all of those materials, but we're just going to do it in open court where there are rules, where the rules of evidence apply, where there's proof, and where it can be done publicly in a way that people will see how it's presented.
When Tom says rules of evidence, what does he mean by that?
Like if you've ever played any type of board game at home, if you've ever played Uno and everybody has a different set of rules and it's like you can't put a draw two on a regular two. Well, the rule of evidence is the judge saying, these are the rules that we're going to play the game by. And you must follow these rules no matter how you do them in other jurisdictions. This is how we play Uno in my house.
Now, that's not all we've heard from Candace and her team. Now, this has been voiced up by a BBC producer.
You don't get to skip discovery just because you're a foreign world leader angry about a podcaster's First Amendment rights. Brigitte's claim that she will offer scientific evidence regarding her gender in court is an obvious and pathetic public relations ploy.
Now, I questioned Tom Clare directly about discovery, and here's what he said.
Subjecting yourself to discovery in the United States, which is, fulsome, much more fulsome than in other parts around the world, is not something that people relish doing. But the fact that they said yes to that, yes, we stand ready to go through that discovery process. Yes, we stand ready to travel to the United States and appear in a public courtroom and explain why this is false. It just demonstrates, one, their conviction in the truth, but it also tells you that they're not afraid. They're not afraid of that discovery. They're not afraid of the truth. If they were, they wouldn't have filed the lawsuit. And so we're looking forward to it.
Now, we've got there in that first line, you don't get to skip discovery just because you're a foreign world leader. Shaun, what would happen if you tried to skip discovery?
Well, you can't. She's not wrong on that. You just can't. The lawsuit wouldn't go forward. The second you file a lawsuit, remember we talked about the Uno rules? The court sets the rules of Uno, and one of the rules are depositions have to be completed by a certain time, statements have to be given, the list of who your experts are. All this has to be given at a certain time. Let's say the court sets a trial date for 2026, 2027. Well, they'll do what's called a scheduling order a lot of times. And in that scheduling order, they'll tell everybody, all depositions must be completed by this date. All evidence to the other side must be completed by this date. And if somebody doesn't do it, the court can do whatever sanctions they want, including throwing the case out. So it is almost impossible to ignore discovery, especially when you are filing the lawsuit.
Okay, so in your legal opinion, would it be a bit redundant to then file a lawsuit if you're not going to participate with discovery or any of the other sort of landmark moments in a case?
Absolutely. We always have the same conversation with our clients. You can sue, but just know they're going to ask you everything at these depositions, all of these questions. There's nothing you can hide from. And you ask them, are you sure you want to do this? And so the lawyer was exactly right. The fact that these people are saying, we don't care. We know we've got to come to the United States at our own dime, by the way. We've got to come over when they tell us to come over. We have to go to Delaware when they want us to come over. And would they get to take our depositions? They will get to see anything we have relevant to this lawsuit and stuff that's not relevant. So it is an onerous burden when you file a lawsuit.
And then in continuation of that statement given to the Daily Mail, it says
The court-mandated discovery process does not allow Brigitte to just submit evidence. The American court system isn't some kangaroo court where leaders can just say whatever they want. Evidence must be independently verified.
So let's focus in on the evidence that we were talking about, photographic evidence. And guys, let me just clear something up here. When we say photographic evidence, we are talking about pictures of Brigitte pregnant and her raising her children, not what some of you have been thinking it was going to be pictures of her this, that, and the other to prove she was a woman. Let me just make that clear. And that's on you who have been republishing this story without giving context. Thank you. So when we talk about photographic evidence and scientific evidence, this is about what the Macrons lawyers said they are willing to present in open court. How does that work? Does somebody need to verify that's not an AI picture, that's not a doctored picture, this scientific evidence holds weight? How does that work?
What ends up happening is Brigitte's people will just put an expert on the stand or put a picture on the stand. And then the other side is allowed to cross-examine, just like you said. They'll have to say, that picture is doctored, that picture is AI. You get to cross-examine them. The difference is in these civil contexts, because of the depositions and the sworn statement, they will have this information early. And then they can say, we don't think it's real. We have got our own experts to look at this information. And this is what our experts are going to testify to it. So there are no secrets. There are no tricks. Everybody will know everything well in advance of the trial.
Okay, so Tom Clare spoke about how the Macrons are going to find this process invasive, but are willing to go through with it.
It is a process that she will have to subject herself to in a very public way. But she's willing to do it. She is firmly resolved to do what it takes to set the record straight. And if that unpleasantness and that discomfort that she has of opening herself up in that way is what it takes to set the record straight and stop this, she's 100% ready to meet that burden.
And here's the part I really want to get into in the rest of this statement given to the Daily Mail by Candace Owens.
During the discovery process, Brigitte will need to submit herself to a third-party medical examination. We're going to demand Brigitte sit down for an exam with an independent doctor. We're coming for her medical records.
Shaun, is that true? She will need to sit down and submit herself to a third-party medical examination?
Not no, but hell no. I mean, that is just such an absolute lie. Like, that's just not going to happen. You cannot force a person to sit down with our doctors. Again, what will end up happening is, now, they'll have to give up her medical records. Her experts will be able to look at her medical records. They could voluntarily allow a third party to do it. And sometimes we do that situation. So at court, they can say, look, we allowed her to be looked at by a third party. But you cannot make somebody sit down with someone else's doctor in a civil context just because you want to. So that statement that is pandering to the public, saying, because that's what you're hearing a lot from the public is, why won't they have her sit down with a third person? You can't make someone do that in a civil lawsuit. It's not happening.
But as part of discovery, the medical records, can you come for all of the medical records? Or that feels like for her whole life? Is that not extremely invasive?
And that's what's going to be interesting. And that's what sometimes, remember, we talked about the rules of uno from the judge and the rules of evidence. Somebody's going to come and say, Judge, we believe this is overburdensome. We believe this is going too far. We believe this is unnecessary. They don't need all of these medical records. Candace's team, I guarantee you, is going to say the opposite. They're going to say, look, we need to know what's happened from birth. We need all of these medical records. We need to see what medicines we are on. They want to know all of this information. So it'll be a battle on what medical records is given. I can see it now. If Candace's team does not get all of the medical records during trial, they'll say, and you've seen the way she is, she'll say something to the effect of, they haven't given us all the medical records, so we know something's missing in this situation. And had we had everything, we would know the truth. Get ready for it.
That is interesting, because when you talk about discovery, how do they know what to ask for without knowing the intimate details of that other person's life?
Well, that's why we have depositions. So what happens a lot of times, you start to ask them questions during the deposition, and it opens the door for like, I need this stuff and this stuff. and you send questions, you send requests. Things are called requests to admit. And these lawyers have been doing these things for a long time, so they know the types of questions they need. And so they'll say, we want all of her medical records from blank. And then what ends up happening is they'll send a subpoena, and you've heard that word a lot. They'll send a subpoena to the Macrons and to her team. We want a subpoena for this, this, and this. Well, a phrase you'll start hearing is the Macron's lawyer will file a motion to quash the subpoena. They'll say that we don't want that out there. We think it's too much information that you're not entitled to. And that'll go back and forth for a long time.
So this is the Blake Lively, Justin Baldoni of it all. Guys, we've done an episode on that. If you haven't listened to it, let me just break that down really quickly. They're subpoenaing for all this stuff, and they're saying they're trying to quash it, and then they're trying to redact certain parts of it. So presumably, if they subpoena, the motion to quash is not granted, right word? Granted?
You got it. Perfect.
If it's not granted, can they then come out and say, she's the wife of a head of state, we need this completely redacted?
Yeah. We could, we don't want the public to see it. This could have national implications. All of this situation is going to come in.
Now, look, I didn't get a chance to talk to you last week about Candace's response and the Delaware of it all. She filed a motion to dismiss in response to the civil complaint by the Macrons. And she says the case was improperly filed in Delaware. It's going to cause her operational and financial hardship trying to defend the case out there. Shaun, I know we had a little conversation before this and you were nerding out. We love to see it. Explain why the Macrons are filing in Delaware, and why, outside of this costing Candace money, why might she not want it to be in Delaware?
And this is my thoughts, of course. But as I mentioned to you, in the United States, when you file a lawsuit, first, people have got to understand that each state is its own jurisdiction. Each state technically has its own law. Think of them as little independent little countries, if you will, under the umbrella of the United States, but they're all separate. To bring a lawsuit against somebody, you can bring a lawsuit where that person lives or where the incident actually occurred. So the example I give is somebody is driving from California and going to South Carolina, and they get in an accident dead in the middle of the country. A person can bring a lawsuit against them in the place where the accident happened. They'll say, well, I don't live there. They say, well, you have what are called minimum contacts. You came through that state. You purposely availed yourself of the benefit and the protection of the laws of that state as you're driving through it. So I can sue you there. Nerd answer. Well, what ends up happening is creative and very smart plaintiff lawyers try to find the best jurisdictions to file lawsuits. You understand? They want to find where people are the most sympathetic. And so what the lawyers try to do is look for jurisdictions. Now, it would have been easy to file a lawsuit against Candace in Tennessee because, again, as we talked about, you can always file a lawsuit where the person lives. Candace lives in Tennessee. You could have filed a lawsuit there. I think one of the reasons they may not want to file a lawsuit in Tennessee as they're looking at it is, one, Tennessee has a 6-month statute of limitation on defamation cases, which means 6 months from the time that she said the defamatory conduct, you must bring the lawsuit. That's a short window. And so there can be an argument that you cannot bring that lawsuit there. But to me, personally, the most important reason why they probably don't want it in Tennessee is, for your listeners, we have what are called red states and blue states. A red state is what is a very conservative Republican state. Candace is a conservative right-wing podcaster. Tennessee is a very red state. So I'm assuming the lawyer said, well, you don't want to file no lawsuit there. That's her base. Those are conservatives. Those are Republicans. We get 12 conservative Republican Candace supporters on the jury. We lose. So they decided to file in Delaware. How are they able to file in Delaware? Because Candace has business that is incorporated in Delaware. Because she incorporated in Delaware, the assumption is the reason people in the United States, almost everybody tries to incorporate their businesses in Delaware. Delaware doesn't have state income tax and is very business friendly. And so the example of us driving through the United States, Candace chose to drive her business through Delaware. And as that reason, because you have purposely availed yourself of the benefit and the protections of Delaware, they're allowed to file the lawsuit in Delaware. Delaware is a blue state, historically Democratic, and it will be very sympathetic. And it's got a 2-year statute of limitations. There's my answer.
But yeah, you're getting a round of applause in the gallery.
Sorry about that. Very long-winded answer, but
Brilliant.
that's the end.
No, it's really good to understand that, because I think a lot of people came out and were like, Candace said that she did not want this lawsuit to be dismissed. She specifically said that on Tucker Carlson's podcast. She was very clear about that. I want to see this through. So then filing the motion to dismiss, we saw a lot of commentary online going, why has she done this? Why is this all about Delaware and where it's filed? And when you explain that, it makes it far, far clearer. So Shaun, the question really is now for the Macrons' lawyers, how are they going to respond? Will they file an amended complaint? Will they take a different legal route? Whatever they do, we will have it here for you first, and we will be following this case. But now, Shaun, we're heading back into some very familiar territory, because we have the sentencing of Sean Diddy Combs happening on October 3rd.
This could happen to any woman, and it is happening to 1 in 5 women, and that's really scary. I was hacked, stalked, harassed, and impersonated. It was a period of absolute hell for me. The story kicks off at a very glamorous London Fashion Week setting. I was getting the coffee.
But you were hanging out in this very, very glamorous kind of environment, right?
Yeah, I was living the dream. I was clueless and innocent, and it was in this very glamorous London Fashion Week setting where I was an intern having the time of my life that I met a man who is actually at the center of this story.
So we spoke about this on the first ever episode of Fame Under Fire. You can go back and listen if you need a refresher. The defense are saying it is unprecedented for Diddy to receive a conviction for the transportation of prostitution when he was only, they're saying only, a user of prostitutes, not a pimp. He wasn't running a prostitution ring. He was a user. The prosecution is saying, wait a second, those escorts, those male exotic dancers, whatever they referred to themselves as, it was different for each guy, they're actually victims in this case. And Diddy was in a managerial role. He was overseeing Jane, who was using a pseudonym, and Cassie, who were organizing these freak-offs, those days-long orgies. Now, we never heard those escorts being referred to as victims during the trial. They didn't refer to themselves as victims. So now the defense are saying, if you're going to go with this new route of argument, we want access to something called 3,500 materials. We want access to that because we're going to argue against what the prosecution are saying. Shaun, my question is, what is 3,500 materials?
3,500 materials, basically Jinx Act material, is what the other way it's called. But, and this is going to shock some people, which is very interesting, is when you meet with law enforcement, you can give a statement. You give a written statement to law enforcement. Seems easy. We always talk about discovery. Everybody should be given everything. Believe it or not, the rule specifically says that the defense is not entitled to a statement, even though it's written, until a person takes the stand and testifies. And then after they're done testifying, technically at that point, the prosecution then gives the statement up. So that is what 3,500 material is, and material that you're usually not entitled to, but you get till after they take the stand. Statements.
You answered my next question there, because it was going to be, is it available to both sides beforehand? But they want the 3,500 material specifically of escorts who didn't testify in the trial, but that the prosecution spoke to. We heard from 2 escorts in the trial. The Punisher, I can remember his name. The other guy, his name not so catchy. But both of them did not present themselves as victims. They actually presented themselves as willing participants, going so far as to talk about enjoying it, etc. There were multiple other escorts or exotic dancers that were named, and we saw pictures of them, but we did not hear from them. So now the defense wants access to those statements, because I'm presuming this is because they want to say the idea of you presenting these guys as victims is ridiculous. Every single statement you took, nobody referred to themselves as a victim. Do you think that's a strong line of argument for the defense?
Anoushka, I give this example when asked questions such like that. As you understand, hate to date myself, 25 years ago, I used to be a prosecutor, and I'll never forget the example. I had a young lady testifying in Charleston, South Carolina. It was a statutory rape case. She was underage. She was dating a young man who was older than her at the time. And I remember she got on the stand, tears just streaming down her eyes, and she just looks dead at me. And there's a jury in the box. She said, Mr. Kent, you can't prosecute it. I gave it to him. And I looked at her in my southern drawl, and I was like, young lady, you can't give it away because the state of South Carolina owns it until you're 18 years of age. She did not want to be a victim. And a lot of times individuals don't want to be a victim. And if you remember the entire Diddy trial, people testified as if they were not victims. It doesn't matter what you call yourself. We have rules and regulations that protect individuals from getting into situations that they don't want to be in, and they might still be a victim. This might be that situation. I'm not saying it is, but the government could say, bruh, there's no such thing as a consensual sex worker. You're still a sex worker. This is still a crime. You're still a victim, period. So that's a thought.
Well, that reminds me, we did that episode ages ago, What is Sex Trafficking, when we were building up to the trial. And I spoke to this young advocate, Lala Applebury, and she was talking about not realizing until a few years afterwards that she was a victim of sex trafficking and kind of piecing the situation back together in her head and understanding it as she spoke to other people. So it is a very real thing. And I mean, are you anticipating that that's what the prosecution will parry with?
Possibly, because don't forget, I think we just noticed, I looked down that the defense filed a 380-page sentencing memorandum. And in there, long and short, they're asking for 14 months, which basically is a time served sentence. And so the government is going to have to file something in response, and they're going to have to swing for the fences. And maybe one of the things they swing is all of these individuals are victims. They're all under the umbrella of him that are all affected. And I think that's what the government's going to have to swing for, because I've peruse that 380-page sentencing memorandum. It's pretty good.
So let me get this straight. That sentencing memorandum, which is long, very long, but that is pretty much what they're going to argue when they get into the courtroom.
That is, and that's one of the great things about it. Not only is it what they're going to argue, it's already been argued. So a lot of times these federal judges are brilliant human beings. They give it to him early. He's going to have it. He's going to review it. He's going to research it. He's going to have his decision made before he goes into the courtroom, because that's their argument. What you and I are going to be watching in the courtroom is basically fluff. And so people are like, oh, why did they file 380 pages? Because they know this is their best chance to get the judge to review it, look at it, research it. Because in the courtroom, going sometimes that fast, he won't have time to go through everything.
And part of that sentencing memorandum where they lay out their arguments is these letters, like character, what would you call them? Character letters?
They're character letters. You got it exactly right. They're character letters.
So we saw this before on verdict day, character letters coming out from the other side, from the prosecution, saying, please don't release Diddy, but we're very scared. This is the other side. This is a lot of letters, like 65 letters.
65 I saw.
One of them is from Carisha Brownlee, Young Miami. We heard about her a lot. Now, I haven't just gone for this because it's Young Miami. Okay.
I know you have. That's the only reason. You're not fooling me.
We have letters from the children. We have letters from his mother. We have letters from people he's worked with. The reason I've picked up on Young Miami is because we heard about her a lot during Jane's testimony. When Jane was talking about, remember that's a pseudonym because her identity is being protected, but when Jane was talking about her experience of being in a relationship with Diddy, she was talking about those days-long orgies, the freak-offs as we know them, not being taken out in public. She felt not being respected as a public romantic partner of him, etc. And she spoke about the relationship he was having with Young Miami at the same time, where she was publicly being flown out, being bought. You know, there's a lot of talk about Chanel bags and this and that and all these designer things, you know, out of my tax bracket. But there's a lot of conversation about what Young Miami was being bought and where she was going, etc. Now, she's written this letter. My name is Carisha Brownlee. I can only speak from my personal experience and the man I've come to know over the past 4 years. She goes on to praise him, how he supported her. One of my most meaningful memories was when he took me to my first Met Gala, how he's upheld other African Americans and opened doors for Black artists. She talks about feeding the homeless in 2022 together and how he does stuff privately without cameras because his heart, quote, is genuinely wants to help people. So she then goes on to say, I've also witnessed him doing real inner work. He made the choice to check himself into anger management, start therapy, and commit to physical healing through therapy. That takes strength, humility, and self-awareness. He didn't do it for show. He did it because he wanted to grow and to become a better person. In my personal experience, Shaun is not a danger or a threat to the community. She finishes the letter by saying, Judge, that's a good man. It's a strong letter in support of his character. But my question is here, that doesn't challenge the narrative that was being offered by Jane during the trial. Jane was saying Young Miami was getting flown out. Young Miami was being bought designer bags and this and that and getting loved on in public spaces. I was the one locked in hotel rooms. I was the one organizing escorts and building relationships with escorts and doing this and that. And obviously he received a conviction for the transportation for prostitution. So if I read that, is there a way that the judge could read that and say, Okay, but that's literally what Jane told us. He wasn't a bad guy to you, but at the same simultaneously, he was doing this with Jane. He was convicted of transportation for prostitution during the same time frame that you're talking about here.
And you're not wrong. And like I said, these are phenomenal lawyers who have done this packet, and it looks great, and it's 380 pages, but there's certain situations, like you've just said, that you have to be careful. In your zeal to get too much, you can sometimes get too much. If you read the 380 pages, one of the things they put in there, there's this lengthy section about, hey, ever since Diddy stopped using drugs, he stopped beating on people. You mean since he's been incarcerated? Like, there's little things that you have to be careful putting things in there. Like, he's such a great person since he's been locked in jail and not able to beat up a woman or get to drugs. You have to be careful on stuff like that. I think the strongest arguments they had, to me, on the sentencing memorandum is, this is what he's been convicted of. This is what it carries. He has no really prior criminal record. 14 months is appropriate. Anything more is just based upon the charges he was found not guilty of. I think that's their strongest argument.
I've seen from lots of other legal analysts and comments online as well that there is a very strong element of this in that they point to other cases where people didn't even receive a charge, let alone a conviction, for the same crime as Diddy.
To me, that's the strongest argument. We have to get past what we think we know and what he was convicted of. And what he was convicted of was using prostitutes. And nobody in the history of using prostitutes without a criminal record is being treated worse than he is. That's their strongest argument. And I think it might actually work.
Well, we shall see. And of course, we will have it here first for you guys, what happens on October 3rd and however long this goes on for. We did tell you this could rumble on for a while. Shaun, thank you so much for joining us today.
Thank you for having me. Much appreciated.
That was our resident trial attorney, Shaun Kent, joining us from South Carolina. Now, remember, you guys can send us your questions on WhatsApp at +44 330 678 1114. That's +44 330 678 1114. That's it for this episode of Fame Under Fire with me, Anoushka Mutanda-Dougherty. Don't forget to subscribe to the BBC Sounds YouTube channel so you never miss an episode.